There's a reason why the panel with the lawyers, this is the third such program we have done. The first one physical, but twice we had done last year, all were online, and every time the panel with the lawyers was the last one. There were two reasons. One is the practical one, because all lawyers are, of course, more available after the second half, after the court is over. And the more strategic one is because, irrespective of what the topic is through the day, given the state of Indian media, laws and what's happening in the legal system flows into each session. So we've had 6 sessions in the morning, and whatever may have been the topic, in each session we have discussed the state of Indian laws, how laws are being used to curtail freedom of speech, and how the kind of legal framework within which media has been operating, and how the system is becoming ever more narrower in space. So therefore, the last session ends up being that culmination where we are always looking at answers. Personally speaking, I think I have far more lawyer friends than any other community. In fact, at my place and my friends, there are more lawyers who meet each other than anybody else. I think that's true for any independent journalist organization, because the only way to survive today is if you have friends with lawyers. I always, at one law school, one journalism school, was giving some talk, and I was saying that it is for the interest of journalists to make lawyers friends very quickly. It is definitely not in the interest of lawyers, because they end up doing a lot of pro bono work over the years. The ones who want to, of course, support the cause. So I'm just, it's very important for journalists to sort of have enough and more legal friends, and not just in cities like Delhi, where you would find enough, support coming in. But the situation is far more adverse in smaller towns, where the excesses of powers are far more. But having said that, just to lay the various issues that have come through the day. Of course, the panel doesn't need any introduction. We have 2 senior lawyers who have taken up cases in defense of freedom of speech, and we have a publisher and a former parliamentarian who's been on both sides. On the lawmaking side, of course, Dr. Singhvi has also been a parliamentarian, or is also still a parliamentarian. But the issue is that sorry. Yeah. It's the intersection of lawmaking, publishing, and interpretation of those laws, and of course the implementation of laws. All of these, the way it is informing Indian media, at least for the last few years, one wonders whether it was always the case. And just to lay the topic again, since morning, because this topic has come through multiple times, we had 2 sessions, one on digital laws, on the entire framework of digital law that the current government has introduced over the last 3 years. I'm going to quickly run through them so that we have a context of discussion to follow. The IT Rules 2021, the Broadcast Bill, the Telecom Bill, the Data Protection Act, the PRB, the Registration of Press and Periodical Act, which has replaced the PRB Act, and the Digital India Bill, which is under process. All these laws have liberally used Article 19.2. Venu was pointing to 19.2, reasonable restrictions. Those reasonable restrictions, at least from the viewpoint of journalists and media organizations, are never reasonable restrictions. They are always unreasonable. They are open to be used in a very subjective manner by whichever government. And it might be convenient for us to say that all the ills of current legal frameworks have been executed in this current administration, but that is not the case. Most of these laws were formulated previously. The system is a legacy of last 70 years. The system has been misused by various central governments. The system continues to be misused by various state governments. So to put one party at the center of it will be unfair. We need to understand the problem, which is systemic. We have these 6 laws, 5 laws already enacted, or various stages of being enacted. One law, Digital India Law, which is being formulated as we speak, and which we are told will be introduced in the next parliament, probably to replace IT Act. And now we have the new criminal laws, which has added more layers of intrusive tools, dangerous tools from what was already there in the existing penal codes. The laws in the provision in the IPC, I think many of us know them by the back of our hand. 153, 295, 505, 502, 124, which is in abeyance. These are almost provisions that are used routinely. They were meant for whatever purpose, but they're used very liberally against media organizations, journalists, where the process becomes a punishment. Now, all those criminal laws have found a space in the new laws, in the new criminal laws, and they've added more layers, which can be used by whichever government. Well, we know which government is going to be here for the foreseeable future, in whichever manner they want to use. The only recourse for us journalists, given the way the state has been sort of closing in, we feel that the state has been closing very rapidly, in fact, in the last 3 years, with these 6 laws, the criminal laws, to on paper to sort of create a very, very narrow system. The only recourse we say is the judiciary. But there also, our faith is a checkered. Sometimes we have judicial decisions which restore our faith, and many times the judicial decision don't restore any faith. The most recent case in point being the IT fact-checking unit, which was challenged in the Bombay High Court. It was split verdict. The third judge will decide on the merits of the case. But even a simple relief of interim relief of government not notifying so-called fact-checking unit, where the government will be the final arbiter on deciding what is fake, what is misleading on its own affairs, on the eve of elections, is something which is just inherently dangerous. That on the eve of elections, the government has been given by the Bombay High Court liberty to put up a fact-checking unit where they will decide what is correct vis-a-vis them. They will control that in the online space, fair enough. But today, whichever magazine we are running, whichever newspaper anybody might be running, whichever television anybody might be running, everything you publish, broadcast is part of your online media. So there is nothing called online regulation. There is online regulation is complete regulation. The newspaper article that you read is a subsection of what goes on the website of the newspaper. Caravan magazine is not a magazine, it's a website more. You control the website, you control the magazine. So given this context where state has been closing in, there is a legacy issue, there is poor interpretation at the law enforcement agencies, or rather I would say the law enforcement agencies are more than willing to hear to the political masters, and there is very ambiguous interpretation of the judiciary. What is the answer? Where is the road ahead? So if I could ask if each of the speakers to, speak for about 8 to 10 minutes, and then we can open up into a discussion. So, yes, please.
Well, it's good to hear a reasonable degree of outpouring of affection for lawyers. Normally lawyers and then politicians and then journalists in that order are the butt of the maximum jokes. You normally hear things like a lawyer is a learned gentleman who rescues his client's estate to keep it for himself. So it was good to hear a contrasting view just now. Of course, I was worried about Venu's left-handed compliment, and a look of alarm crossed both my and Shyam's face, because it seemed like a very clever marketing gimmick to get more donations out of us. But friends, I think this is a very important body, first of all. Possibly the only reason why you are not being intruded upon is because the name of the body is Editors Guild of India, and you're able to discuss things relatively more freely. There's also no doubt that a free press is the first and the principal enemy of any dictatorial tendency, or of dictatorship for that matter. I found an interesting definition of a dictator, or rather interesting definition of a free press in the context of dictatorship, and that is one that prints the dictator's speech but does not have to print it. And I think that essence of freedom. Now, the topic you have for this session, obviously the guests have to stick to the topic, the speakers have to stick to the topic, but I think there is an inherent fault in the equation in the way it is drafted. It is placing a lot of emphasis on law. And certainly law is important. It's the ostensible normative thing which you see. Certainly law has been in the recent past, especially in the last decade, it has suffered a regression as far as press freedom is concerned. Certainly the text of the law has been tightened against press freedom, and so on and so forth. But why I start with this first aspect is that putting the equation merely in terms of law is sometimes missing the wood for the trees, because the nature of the law itself, of any law, it doesn't have to be this government or the last government's. any law's nature is a wide band of discretion, a wide band of subjectivity. And therefore, more important than the law is the approach to the use or the misuse of that law. And that is really where the nub lies. You can tweak the laws all you like, it will still not serve the purpose, because the sad truth is that whenever you have a tendency to control, whenever you have an approach to control, you will be able to twist and misuse a law unless the law is very, very specially made, which it is not. And therefore, the first point I want to make is that do not be over concerned with the law. All laws are broadly equally bad or equally good. Of course, I don't mean it in a general sense. As I said, there is a regression which I'll deal with in a moment. But it is really how you approach the subject of the law and how you deal with it, how you implement it, how you regulate it, how you act under it. And I think that is where most of the diminution of press freedom is happening. But since it's the prerogative of the organizers to decide the topic, so let's come first to the narrower topic, which is the law. Now, there are many examples. We could go on, but let me choose a few of my favorite ones. One is sedition. They were dealing with sedition, but in that process, those who dealt with it have done the great betrayal. Most of you know the dates, and I'll tell you in a minute why it's a betrayal. On 11th of May 22, the Supreme Court stayed actions under that old provision. A statement was recorded by the senior-most two officers, law officers appearing for the central government, saying that everything shall be kept in abeyance, no FIR shall be registered, and we intend to, the word used was revisit. It's an Alice in Wonderland new definition of revisit as to what happened thereafter. This was repeated by a second interim order in October of 2022. Everybody thought that there may not be a complete abolition, but there will be a significant tweaking. Many thought that there would be an abolition. Along comes suddenly, after almost a year of the original date, on 24th of May of the next year, 23 to be precise, a law commission report, the 279th, which actually gives a recommendation of full-blown sedition, more comprehensive, more strong, more anti-people, anti-free speech than the previous one. This would be almost comic, were it not tragic, for civil society, if this was the meaning of revisit. And I remember some of your press reports immediately after the Law Commission report, with the government expressing surprise, as if it came from they said this is from an independent body, the Law Commission, and as if it came from a stranger, which was even more surprising. It underlined the larger concept of betrayal on sedition. Finally, you have in the BNS, the ultimate fudge, the camouflage. You drop the word sedition, but you have provision which is in the second half equally or even more vague, 152. And it allows the same amount of discretion, of arbitrariness, of harassment. I'm not talking of the examples yet. They are more important than the law, but I'm just now talking of the law. And you have 7 years of life as against 3 years of life earlier. So it's quite amazing that you have right up to the Supreme Court all kinds of assurances, statements. You have a period of 1.5, 2 years. But a ziddi approach, an obstinate approach means you come back not full circle. According to me, you go beyond full circle. And possibly you have created a bigger monster than the previous provision. Of course, as I said, I give much more weight to how you approach the subject than to the text of the law. You see, India has common law. Common law means that you decide individual cases. So there's a case between A and B and it's decided by a third individual, a judge. He may get it right, he may get it wrong. There's another case between C and D and that is decided by another person. That person may get it right or wrong. But it's an iterative process of individual decisions, and at some point of time, the accumulated weight of those decisions possibly get you the right result. But the point is, it's a very ineffective process if the government is determined to get its way in the meanwhile. This process takes a long time. There are situations where the entire law has been changed by the Supreme Court after 5 years, but in those 5 years, the law has been complete opposite of what the Supreme Court changed. And that process is the punishment in India. It is enough to have that process, which you assume will ultimately be corrected, but it will go through the vagaries till it reaches the apex court. And I think that process being the punishment is really what the government knows and what the government intends. Even to the extent that sometimes they know we are doing wrong, it is likely to be stayed, likely to be challenged, likely to be struck down ultimately. But so what? We'll pick up a few, pieces along the way while that lasts. The other example is 185 of the Samhita, read with related clauses like 94 and all. Very, very specially wide language has been used. I'm still sticking to the law and not to the larger issue, about search and about the definition of material or documents. Virtually everything. I don't want to bore you with technical, you have the provisions with you. The words used are any kind of material, any kind of document, and well, it's all from digital to hard. And then you have the Telecommunications Act now, which has the most remarkable, I don't understand the meaning anymore of end-to-end encryption. That end-to-end encryption must be a joke of a sentence, because it says anybody can be directed to intercept, detain, disclose, suspend any message. And the message is defined in turn as any sign, signal, writing, text, image, sound, video, data, stream, intelligence, information, etc. I must commend the draftsman. Is the most comprehensive, inclusive definition I could ever have imagined. It's used for negative purposes, but it's still very commendable. Now, of course, the Editors Guild of India rightly called it the most draconian and all that. But that's so much par for the course. Doesn't make much difference. There are similar things in the Press Registration Act for the print media more than the visual media. I was quite amazed to find that one provision is, when you start drawing a bigger line near a smaller line, you start looking at relativism. So one provision is relatively more benign because it seeks a conviction, a prior conviction, before you can take action. At least there is some threshold there. The second provision there allows you to stop anything which is done against the security of the state. They're the exact provisions of the amendment. It's the most vague and subjective, powerful tool to deal with the press. Diminution of press freedom, censorship, direct, indirect, etc. Of course, the most egregious example, I'm very sorry and sad to find, not because I agree with the view, but because I have said so openly, one of the most outstanding judges in the country, Justice Gautam Patel, did not find support from his bench partner, and therefore something to my mind obvious as daylight. You see, fact-checking is one part, and one is not necessarily against fact-checking. But fact-checking has to be by an independent regulator. It's as simple as that. I'm not even sure whether you'll get the independence requisite in a regulator. But here it is so brazen, they don't even attempt to have a regulator. They simply say that the person who will stop it will be the person who will decide the fact itself. Now, it's as simple as that. And the entire arguments went on the basis of being the mere ipse dixit of the interested party, which leads to the suppression or the censorship or the stoppage. And it's so easy ultimately to find that the fact was correct, but to temporarily stop it, to lose its news value, to lose all relevance. And that is the object again. The object is where you are not successful, the process is the punishment. Where you are successful, you are doubly successful. And there, unfortunately, not only did the bench partner did not agree and therefore the matter was referred, but now I find that the reference has denied a stay by the third judge. I totally disagree. I hope and trust that it is carried vigorously and properly to the Supreme Court, and I would still expect on purely established standards and paradigms of law that there should be something done about this judgment. But let me now hearken back as I wind up shortly to the topic beyond the law. I think we're only nibbling at the edges when you talk of law. I've given 4 examples. I'm sure my friend will give 5 more examples and others will give more. This is nibbling at the edges. In a way, law is perhaps the weakest and the most accountable way to control the press. There are many better ways to control the press than by law. And I have given the sedition example above, but then how does it operate in practice? I have appeared in cases of sedition where a person has been charged with sedition in Gujarat. He's now my colleague in the Rajya Sabha. Possibly that even got him a Rajya Sabha seat. He's caught in Gujarat by the Assam police for tweeting. I've done the case myself. A colleague of mine was stopped at the airport and would have been picked up on something which was seen as anti-national virtually. Now, I told the court, I said, I don't agree with the way my client has put it, and I probably would not put it this way. But whatever it is not sedition. Now, the object of these cases is that they know that ultimately there will be bail, there will be stay against arrest, there will be release, there will be relief. But the first person, the Gujarat example, spent 3 years in an Assam jail. The second example, I stopped the same day because I was in my legs before the court in the Supreme Court, and somehow they took it up on an oral mention. Otherwise, he would have suffered at least a couple of months. That's good enough. The object is to send a message. The object is not to be right in law. The object is not to get a judgment in law. But there are, as I said, so many other facets of it. Facets which seem unbelievable a few years ago, but and they don't require any law. They don't even require any intrusive action. Do you know, for my own book release, I had 2 anchors and I had a multi-party panel on the stage. 8 political parties, including a BJP sitting minister, very powerful ministers. This is like 10 years ago, 8 years ago. I had 2 books. One was edited a compilation of my father's work, and another was my own book. It happened about 6 months apart. It happened in multipurpose hall below here. In both cases, the ministers telephoned me 3 days earlier and said, we didn't realize that this was the anchor you have for moderating. But we have an instruction in our party that we cannot cohabit or interact with these anchors. Now, what a wonderful way to excise censorship. Each of you know the names of those 2 anchors. I joked with one of them, I said, you hold the 2 most important portfolios in the country and you can't sit with an anchor with 7 other people on the panel. Now, this is a way, I'm not saying that anchor is good, bad, I'm not saying he's right or wrong, that's irrelevant. But this is a way, somebody is giving the example of a press pass, but this is a way of making you a pariah, ostracizing you, making you a persona non grata, and I commend this government. I genuinely commend this government for doing it successfully. Not to 1, not to 2, but to many. It's still operating as we speak. Now, you may have all kinds of things about all kinds of governments, but no other government, including the government of the same political color as now rules the roost, has ever thought of doing it, much less done it successfully. This is more effective diminution of press freedom than any law you can think of. And law will have a chance of being struck down. This has no chance of being struck down. So you actually then divide people. And of course, none of these raids, none of these questions, none of these intrusive actions, and we have many victims of those intrusive actions sitting here. None of them happen if you are part of what you are euphemistically called Godi media. None of that happens if I keep chanting to see great hope. That is another form of very effective diminution of press freedom. And that is happening under our noses. It is happening every day. It is partly happening because your body is divided. This body, I don't mean this body, but I mean your tribe is highly divided. After all, the Godi media is part of a subset of your tribe. And either it is not called out, or if called out, it doesn't matter, there are no consequences following. So I think these are the far more insidious incursions into press freedom than the mere legal issue. Let me end by saying that these surveys, of course, are not definitive. But we have in almost every international survey, and they are dismissed by the government, they're entitled to dismiss it. They are called anti-national sometimes. And I don't consider them absolutely accurate, but they give a trend. I have them here, I'll not bore you with the details. Almost every survey, at least I have the figures from 2019 onwards, shows us going downer and downer and downer on the index of press freedom. We are, in one of them, we are 163 down from 150. And I was surprised to find Pakistan is 150, Bhutan is 90, Sri Lanka is 135. This is without talking of physical harm to journalists. The number in India in the last few years has been almost 70 physically harmed journalists per year, the maximum being in Jammu and Kashmir. These are all published figures. This is not my imagination. One of the horrific ones is, and I don't agree, I mean, I'm one of those who appear in court for many people I don't agree. I believe it genuinely in the fact that lawyers cannot choose their clients and should not judge their clients beyond a point. Of course, there's some judging involved. So I appear frequently for people with whom I don't agree. I don't agree with possibly the way Kappan would put his views. I don't agree possibly with the three people I've represented, Gonzalez and the other two from that, what is that thing called in Maharashtra, that Koregaon incident. I represent all. But here is a man who went for a gang rape case in Hathras and he spent already 4 years. I think we've all forgotten him. He's already 4 years behind bars. So why do you need all these laws of press freedom to diminish press freedom? A direct order under these laws would be challengeable, would be stayed. So, may I end by saying that it's time we woke up and smelt the coffee. It's time we realized that the Orwellian scenario of Big Brother always watching everywhere is not happening on some other planet far away. It's right here. It's right in between. And it does not appear that there's much. We can do something. We can have meetings like this and at least create awareness. But it doesn't appear to be much, much more that we can do. Thank you.
Tathagata, if I can request you to give your opening remarks.
Can I speak from here?
Yes, of course.
Would you like to speak first? With such larger than life two gentlemen sitting beside me, my hands are shaking. I do not know what to speak about law. But with my little experience, what I've seen, the present situation is unique in one way. It has brought about a lot of regulatory uncertainty, or I can even term it as legal uncertainty, which is troubling reporters at the Mofussil level, at the village level, at the district and block level. It is difficult for them to operate. And no matter which party is in power where, it's not the political parties. They are all, I realized being in politics myself, they're all the same. There's very little difference between them. One may seem rosier at a certain point of time, but at another point of time, you realize the characteristics are the same. For example, when the UPA was in power, the UPA was the one which had sanctioned Z-class security to Mukesh Ambani. And when the Congress government came in Telangana, the first thing they did was sign an agreement with Adani. So Ambani, Adanis and that kind of people, they do not belong to any party. They belong to themselves and everybody kowtows to them. But this regulatory uncertainty is actually taken advantage of by a select few, whether they are politicians or businessmen. And the main machinery that assists them is not, it's not the Supreme Court or the High Courts. It's the lowest of the low judiciary, the municipal level, the not even the district courts, lower than the district courts. So what is happening is, by the time a journalist has to fight his case of defamation, or they can even slap false cases against reporters, by the time he fights or she fights and keeps climbing up, it is so expensive, so time consuming, that even the toughest of them actually falter and they fall. So we only, when we are sitting in New Delhi or Bombay, we are only focused on the Supreme Court, what Mr. Singhvi does or what Mr. Divan does. But they are the highest of the high. Reporters are at the base level. And there was a time when goodness or acceptance was counted on what you did. Now it is, I think, considered what you have not done, whether you are good or bad. I don't know if I'm clear on this aspect. So the lower judiciary is the major problem for media, and like Mr. Singhvi said, the laws, the big laws, are not really, as yet they haven't percolated down, but very simple sections. A municipal court can keep on denying bail for virtually no crime at all. So in that sort of a situation, when I hear of editors complaining about freedom of press, freedom of speech being hampered, on one side I accept that. On the other side, I also tend to agree with some thoughts that these were people who had tremendous power earlier. They could decide, some of these editors could decide which candidate will fight which Lok Sabha seat, who would get a MLA seat or not get a seat. They would be the dealers, they would be the go-betweens. But suddenly that ability has, that scope has shrunk. That money making, that clout, all that has come down. And that could be troubling a few people. But generally, an editor like Tathagata Satpathy has to deal with daily problems of reporters. And that is very difficult because even if I want to give protection, I do not have the wherewithals. I do not have the legal knowledge. If I can hire lawyers also, it is a question of money. And at the state level, at the lower levels, you hire a lawyer and suddenly a sub-inspector goes to that lawyer's house and says, what are you doing? Who are you supporting? Come, the magistrate wants to talk to you. And the magistrate gets his fish, his vegetables, his daily requirements from that sub-inspector, whichever thana that court comes under. The SP will call up the magistrate. The collector will call up the magistrate or the sub-judge. And they will tell the lawyer, okay, you've got so many cases. What are you doing? Why you just compromise and do something and finish it? So he will not openly tell his client who's paying him, when it's a journalist or when it's an editor, that, let's bring everything on the table and let's sort it out. No. What he will do is he will take a date after another date, after another date, after another date, and tire you out. And you keep spending money. So these are practical problems, and it is very difficult to handle that sort of a problem at the ground level.
So Shyam, thank you. Shyam, while you address the larger question, one additional question, because we have worked as part of Guild on a more than a few petitions, whether it was sedition, it was the Pegasus petition, of course, with us, and then the Manipur case, and then there were the FIRs that were filed against some of us around the 26th January, tweet, the death of the farmer, and I feel at least we have had moderate to more than moderate success at the Supreme Court in at least tempering the onslaught. Given the situation is upon us now, we don't have a choice. We are living in this environment. it is a pessimistic environment, but we are looking for hope. We are desperately looking for hope. So we need some answers. Where do we work towards, and what will it take for us to work towards that hope?
Okay, thanks very much. No, so I'll just answer that first in a general level and then individually. I think in a democracy, optimism is an obligation. It's a duty of every citizen. So please don't be pessimistic. That's one. Second, I hark back to something which I picked up from Mr. Fali Nariman. This was, I remember, it was in 2007. And we were just chatting in the corridor of the Supreme Court, and I was just asking him that in the breadth of his vast experience, where was the court today? And he answered that, look, Shyam, is there a single judgment which has come out recently from the Supreme Court of India which you feel like reading? And, I think that was his way of conveying that, look, it's not as good as it used to be. At the same time, let me share with you, I think Abhishek just mentioned a short while ago Justice Gautam Patel's judgment in the Kumar Kamra case. And there is more recently a judgment of Justice Oak, which he rendered in the context of dissent. And I think we should all read those judgments because they really make you proud that you have judges of tremendous caliber, of tremendous integrity, who still come through our system and who are willing to, uphold freedoms, including the freedom of the press. And so you have to be optimistic. That's my first point. The second point is that as I understand, there are many of us, and I think I would count Abhishek and myself in that group. We're sort of, as Abhishek indicated, lawyers who are trained to argue and present the brief which is delivered to us. So we use our experience and our skills such as we have to try and persuade a court to a particular point of view, regardless of, whether we agree with the client or not. But then there are these other, what you would describe as cause lawyers. So there are lawyers who identify with a cause, who will take up a cause. And there's a little bit of that in each one of us because we do it pro bono, for example, in the cases which you mentioned. We feel about this. I think there is a need now, having regard to the huge across India problems that you have, for organizations like the Editors Guild to really build a coalition of lawyers, not necessarily only cause lawyers with a capital C, but lawyers who are empathetic to a free media, build it across the districts, etc. Build these coalitions so that if journalists land up in trouble, you have someone of integrity there. I think there's also a need, and we've discussed this as well, there's probably a need for something like a playbook or a workbook or a toolkit or whatever, a cookbook, whatever you wish to call it, and have that sort of structure available as a first reference point, because you suddenly have journalists who are finding themselves entrapped by statutes which, at least on a reading of it, are sort of impossible to overcome because of their vagueness, which was mentioned, because of the oppressive power of the state. So I think this coalition between lawyers, members of the bar, and journalists at the ground level, maybe across the country, is a new kind of institutional design that we need, having regard to the times. The other point which I wish to make is that while you have the laws and you enumerated a number of them, I think you're going to have situations where even the most innocent law is going to be weaponized to an extent that you just, you're suddenly found in a very, very difficult spot. And I pick up from the last session because IPSMF was mentioned over there. So one small point of clarification, by the way, as far as the wire funding is concerned, is that IPSMF has a rule that they don't, the foundation doesn't extend help for more than 3 years. I think for the purpose of wire, it was extended for a 4th year, if I'm not mistaken. But that's absolutely the limit, because the philosophy of the foundation is that you've got to be able to, stand up and run within that period of 4 years. But the other aspect of IPSMF which I want to raise is that they've used the income tax laws essentially, which are standard provisions for reassessment, for cancelling your status as a charitable foundation, etc.
And these laws are being used essentially to frighten away what eventually would trickle down to the media by frightening away donors and by frightening away frightening the foundation itself from making grants, and then slapping huge notices under the Income Tax Act, which obviously results in drying up of resources. So that has to be fought, that has to be contested. There remain, fortunately for us, people who are sort of steadfastly, realize and recognize the importance of independent media, which brings me to the other point. And the other point is with regard to perhaps a need. I noticed, for example, during the last session, that there were discussions on new structures, on how to organize yourselves as digital media spaces, revenue streams, etc. So there's plenty of lessons these days on, asymmetric warfare at a certain level, or asymmetric defense. And you're seeing this every day when you read the news coming out, for example, from Ukraine, where you have these massive battleships, for example, brought down by some sea drone, which, costs a few $100 or something like that. I think media may have to restructure and reorganize itself, and it probably already is to some extent, and we see it actually, of probably not having very large media houses. I remember hearing the word may not be scalable up to a very large level, but maybe the way forward for independent media, for media which is, ethical and strong and values journalism, to remain small, to remain targeted, to of course ensure that there is sufficient revenue, remain impactful. That might be a better strategy in terms of meeting the challenges of the time. So these were just a few thoughts. Thanks.
I think the suggestion on the coalition between lawyers and journalists is something we are taking very seriously. The Guild has, of course, our own panel of lawyers in Delhi. But tomorrow, in fact, we have a meeting with various press associations from across the country. Some of them are here. We've been writing to them that one possible way is to create a national directory of lawyers from each region, which each local press club has sort of vetted and has taken consent that they are the first point of concern. And again, I think I'd echo your point, they need not be cause-based lawyers. They are lawyers who feel empathetic towards this cause. They may not even work pro bono all the time. I mean, it's not, it's not a fair ask that everybody who feels for the cause may be able to work without, with pro bono, but at least have lawyers who are willing to advise, willing to give you the first point of some strategic way out when the policeman, usually this is the policeman who comes knocking down the door. Civil cases are easier to handle because those have a far more longer gestation period. The greater problem is when a state agency or a policeman comes knocking down the door, and so we are working on that. But one follow-up question, actually we are running short of time because the next session is going to start, the next program is going to start. But just two broad questions and, to open to the panel. The criminal laws were always there. They were being used against us. New criminal laws have come in. Sedition has been replaced by something which is now being called treason. Shyam, we have discussed this when we were looking at sedition law, that given the kind of work journalists are doing now, reporting on an ethnic violence can itself be called a crime. The fact that you reported that there was a violence between a Hindu and a Muslim community, just reporting that fact can itself be a ground for a policeman to file or somebody to file a complaint that under 295 or 153A or whichever other provision is relevant in the new laws, that you are inciting violence by writing about the fact. And then they land up with an FIR. The fact that journalists are now playing with fire, so to say, is there a possibility for creating a protection for journalists? Because we were talking about this in sedition law, obviously that we never came to that point, but with all these new laws, can journalists be given a certain layer of protection before a certain complaint is registered as an FIR against them? Just like doctors maybe have a certain kind of a protection while working, discharging that, just like parliamentarians have a certain protection under the privileges protection. Is there there is a time that journalists need protection, but is it possible? And second question is slightly more, I would say, one may say a very tall, grand question. Given the last 70 years history, we've seen how 19.2 has been misused rather, in every possible law. is there any movement at any point possible where 19.2 can actually be done away with? Is there a fair expectation to keep in our lifetime where 19.2 to be done away with? Because we have seen there is nothing called reasonable restriction. US as a model of absolute freedom of speech. There, the First Amendment guaranteed you absolute freedom of speech. Ironically, in India, the First Amendment added to the words say sovereignty of the state or friendly relations with the state. Some two more additions were added. So our First Amendment expanded those reasonable restrictions, and they have now been abused, disabused, whatever. So one is a tactical question, a layer of protection for journalists in criminal laws, and B, is there a way to actually argue against 19.2 at any point?
So, our time is short, so I'll be very pointed. You made very good 2 points, very optimistic, as Shyam said, but the realist answer, sadly, is no. These two are very not the second one, I don't agree so much, but the first one is very desirable. But you are looking for an amendment by the very same people who want to control you. So I think it will be very unrealistic for us to fool you by saying that unless Parliament takes this initiative, you've had these filters, nothing to be done without prior permission. That's what you're really talking about. But I don't think it will be done by courts. It can't be done by courts. And to expect a dispensation to do it, certainly not this, but I would say very few other dispensations would do it. So I think you will really be in a fool's paradise. The second one will not happen. That changes the architecture of our constitution. We have an architecture different from the US one, which are more absolute. And that, I think, should not really be tried also. I think the real thing we are missing here is two things. One, we have to constantly strive for consistency in courts. So the moment one judgment comes of the court, which is clear-headed, take, for example, the electoral bonds case, it sends a clear message across the country, down and up. The problem, and I fault the courts for that, including the High Court and the Supreme Court, too much inconsistency. We joke that in our 16, 18 courtrooms, we may have at least 15 Supreme Courts functioning. So that sends a signal, which is today you are exulting in a judgment X. The same judgment is diluted, zigzagged, and made inconsistent later. That is something the courts, if they remain consistent about freedom of speech, about tweets, about how much you can file sedition cases, you will find within 10 cases, the message goes down to the lower judiciary, right down to the bottom judiciary, as is saying. And then people are able. Today, the district judge says, "Kare, मैं आज ये कर दूंगा, कल मेरे माथे पे डंडा पड़ेगा कि आपने गलत कैसे कर दिया." So he doesn't risk it.
Yeah, I'd just supplement that by saying that, look, we can't, beyond a point, put too much faith in our judges either. I gave a few examples, and that is exceptional. So I would say that it's worth a crack. Journalists don't enjoy any special degree of freedoms under our constitution. The media doesn't have any special rights as such, but through a process of interpretation, that space has to be preserved and expanded. So when you have examples coming to the fore, as you often do now, where you have comedians and cartoonists and journalists being subjected to long periods of detention, I think it makes out a case for some kind of judicial safeguards. We had, if you recall, a spate of negligence actions before consumer fora against doctors. And the experience of judges, many of whom were being treated by doctors who must have complained to them, was that, hey, what's happening over here? We're just being subjected to, very, very stringent standards by these consumer fora which don't know. And so the Supreme Court built in certain safeguards before you could proceed in negligence actions. So I think it's possible. But look, let's not forget that as far as there is a difference between doctors and journalists. Journalists and those who report in terms of qualification, many stripes, huge range of types of people that you have in that particular field. So maybe some safeguards may come through a judicial process, but you have to be optimistic for that. It's worth pushing for, is my sense. I think in terms of the balance, I completely agree with Abhishek that our society is founded on a certain understanding, and we've negotiated our rights in a particular way. So eventually it's going to be, we have to hope that the first sort of line of defense, which is your bureaucrats charged with implementing these laws, do not extend the abuse or keep pushing the envelope so as to constrict rights. But that's again a little bit of optimism. I'm not very optimistic in the sense, if you see the what's happened in the last 3 years, for example, in Hong Kong, both as far as, less so as far as rule of law is concerned, but certainly as far as journalism is concerned, the slide downwards has been very, very rapid. So I think time to fight right through.
The last comment, and then we'll wrap it up.
I'll take a minute. My belief is that we are just entering a new stage in India, and I would label it as the deep state. And what Mr. Divan just said, the bureaucracy, it's the bureaucracy actually which is gradually encroaching on all fields. And in a country where everybody is so distracted, for example, if the Supreme Court had to go back and insist that the State Bank not get any more time and has to file the details about the electoral bonds, is there anybody questioning that how come somebody from the State Bank, within the State Bank, ordered that the lawyer should file a petition for time? And who is that person? And what is his credentials? Will he be punished? Will he be hauled up? We do not have a system like that. So it is the deep state. I am very convinced that we are just entering the deep state. And I come from a state where I'm experiencing that on a daily basis. And therefore, let's prepare for the new India where politicians and the Congress, for example, during the UPA time, had the same laws, had the same system, everything. But because they were a distracted lot, they didn't know where each one was going. The bureaucracy could not cotton on to anybody individual. But in the present thing, there's only one man, all the others are nobodies. So they have caught hold of that person and they're happy. And they're regulating everything. And the experiment is on. We'll have to see whether they succeed or, like people are saying, democracy is at threat. We will all see what happens in the near future.
Okay, thank you. I think that's about the time we have. We will still end with a note of optimism and hope, because we have seen putting up a fight at least slows down it diminishes the thrust of the blow, or sometimes it even creates a space. We have seen that. Judiciary, our hope is not lost. I think we have to keep on knocking at the door of judiciary. We have had, in fact, we have had great successes in the last couple of years. Sometimes it's been checkered, but sometimes there have been more highs than lows, at least at the higher judiciary level. And therefore, we need to keep fighting. I think the message for all of us is publishers, editors, journalists, lawyers. This collaboration needs to be deepened at all the levels, from Delhi to all the way to the last town. Thank you, everyone. We have to finish it up. Thank you, sirs, for coming over. Thank you again, everybody. Thank you, the entire membership of EGI, people who supported us, APJ Institute, VIPS, Gul and Betwa and Digipub and Abhinandan Sikri. Thank you all and Bhubaneswar Press Club, sir, for supporting the event. Thank you.